Welcome to the fourth episode in the first season of Justice Centre Weekly. Joining me today is John Carpay, President and founder of the Centre. John, I understand you're set to testify at the National Citizens Inquiry into Canada's Covid-19 response at 1 p.m. on Friday, April 28th in Red Deer. What is this all about?
So these hearings in Red Deer, Alberta that are taking place through to Friday, April the 28th are part of a cross-Canada tour. The hearings have already been held in Ontario, Manitoba, Saskatchewan, BC next week, May 2nd, 3rd, 4th, at least those 3 days, possibly the 5th as well. And this National Citizens Inquiry is doing something very important, which our federal and provincial governments ought to have been doing themselves in the past 3 years, since March of 2020, when they started violating our charter rights and freedoms, namely the freedoms of association and expression, conscience, religion, peaceful assembly, mobility rights to travel, the right to bodily autonomy, et cetera, et cetera. What the Canadian Charter of Rights and Freedoms requires is that whenever a federal or provincial government violates any charter right or freedom, the government must demonstrably justify with evidence that that government policy is bringing about more good than harm. Now, I'm oversimplifying the legal test. The legal test was set down by the Supreme Court of Canada in a case from about 1986 called R.V. Oakes, and so it's a very complex, nuanced test. So I am oversimplifying it, but the bottom line is still that the government needs to demonstrably justify any law, policy, health order, regulation, any type of government action. If it violates charter right or freedom, the onus is on the government to show that the benefits outweigh the harms. Governments have not been doing this since March of 2020. They have been blindly, fanatically moving along with first lockdowns and then later vaccine passports, violating everybody's privacy, requiring everybody to disclose personal, private medical information to total strangers, all the travel restrictions. It's been a fanatical approach where the government has already concluded ahead of time that the lockdown measures and vaccine passports and travel restrictions are wonderful and necessary. And governments in Canada, neither provincially nor federally, have they done what they're supposed to do, which is to carefully, thoughtfully look at and weigh the harms and the benefits of lockdown measures.
Okay, so how do you see your role in this inquiry? You basically going to make recommendations to force them to do that, or bring about changes that will make them do what they should have done all along?
So on Friday the 28th in Red Deer, I will be making presentations about legislative changes. So changes that the federal parliament can make to federal legislation and that the provincial legislatures across Canada can make, so that for a future public health emergency, there are better laws on the books than the laws that were on the books in March of 2020, which have given way too much latitude to unelected, unaccountable chief medical officers to turn themselves into effectively behave like medieval monarchs who have absolute power over their citizens without any kind of scrutiny, without any accountability, without any debate, without any legislative input. We've been governed by, Queen Dina Hinshaw in British Columbia and Queen Bonnie Henry Queen Dina Hinshaw in Alberta and Queen Bonnie Henry in British Columbia, and so on. These chief medical officers have functioned like autocrats without accountability. So we need legislative changes.
Right. I guess that's probably a pretty good segue to turn to the paper itself that you're going to be presenting. Now, maybe you could start with your top recommendation right there.
So at the top of the list, we need transparency with the public, which means that federally and provincially, the Parliament, provincial legislatures need to change the laws such that the chief medical officers and the health authorities will be required by law at all times to disclose the actual scientific papers, sources, documents, and data on which they rely. And this was strikingly absent the last 3 years. The word science was being chanted over and over again like a mantra, with all the claims that, if you agree with me, you're pro-science. If you disagree with me, you're anti-science. We're all about science. All of these laws are based on science. And science became this slogan that was used to beat people over the head with. But when you probe deeper and said, okay, can you tell me what your sources are? When, for example, in Alberta, the Kenney government on April the 8th, 2020, released a paper, a fear-mongering modeling chart predicting that even with lockdown measures in place, as many as 32,000 Albertans could die of COVID. Well, I've asked, where do you base this 32,000 number on? It's higher than the total deaths from all sources, which is about 27,000 people per year, which you would expect in a province of 4.5 million. But here the government is fear-mongering, saying that 32,000 people could die of COVID. Yet when they're asked, where do you come up with this number? Did you pull it out of thin air? Is it based on the Neil Ferguson models? How did you come up with this? You get no answers. And it's the same with so many asymptomatic spread. The government insisted that COVID was spreading asymptomatically, so that people without any symptoms were all passing COVID around to each other. I wrote to governments all over Canada. I said, what's the scientific basis? Show me the scientific evidence where it backs up your position that COVID spreads amongst people without any symptoms. And you don't get anything. So this needs to change by law.
I'm just wondering how difficult it would be to legislate disclosure like that. I guess that's the one thing, trying to think about how it would actually work. But I guess that's really not our job. Our job is just to set them straight and they can figure out the details. Okay, moving along then. What else have you got to recommend?
So the government should use existing emergency response plans. We've become familiar with the World Health Organization having emergency response plans that were revised and updated in late 2019 and did not advocate the non-pharmaceutical interventions, i.e. the lockdowns were not part of that plan. It was a brand new experiment that was embarked upon for the first time in human history in March of 2020. And so we had plans, we didn't use plans. And so this needs to change. We need to use the existing emergency response plans that are already on the books, and they should only be departed from if there are good reasons for doing so. In terms of how you translate this into law, Kevin, I'm glad you raised that point. Much of the language that's in this paper, governments could cut and paste and put the language right into the public health legislation, which every person has, and there's federal legislation as well. But you are correct. Like the fine tuning of the details of which pieces of legislation should be amended and the specific wording. Every legislature has a team of legislative drafting lawyers that are on staff that will be able to handle that.
Right. Okay. I guess that would probably be a good time now to bring up the third recommendation, because that actually speaks to the actions of the legislatures themselves.
So the declaration by the public health, the chief medical officer, if he or she declares that there is a public health emergency, that needs to go for a debate before the federal parliament or the provincial legislature, again, both levels. And the evidence that the chief medical officer has needs to be presented and made available to the MPs or provincial MPPs, MLAs, etc., so that members of the parliament can see. There needs to be debate. There needs to be a free vote. And that public health emergency, if it's approved by the parliament and or the provincial legislature, it stays in place for only 30 days, at which time, if the chief medical officer wants it to continue, we need to call the MPs, the MLAs back for another vote. And anybody who thinks that it's expensive to call a bunch of politicians back to the parliament, it is a fraction of the cost of the tens of billions, hundreds of billions of dollars of economic destruction that were inflicted on this country through lockdowns and through increases in public debt. So pretty small expense to get the MPs back to Ottawa to get the provincial politicians back to the provincial capital.
Right. So it sounds like no more executive rule then, no more rule by just the cabinet and the chief medical officer. I think that's what we're trying to do here, right?
Exactly. In conjunction with that, ongoing accountability, the chief medical officer needs to, and this again federally, so it'd be, Theresa Tam getting questioned by an all-party committee of the House of Commons at least once a week, having to answer questions, having to produce documents when they ask documents. Same thing provincially in Victoria, Edmonton, Regina, Winnipeg, Toronto, every provincial capital. The chief medical officer of the province needs to make himself or herself available to questioning by a committee of members of the provincial legislature for questioning, and that includes having to provide information subsequent to that hearing. So the chief medical officer might get asked, okay, where is your evidence to support your claim that this virus is spreading asymptomatically? If the chief medical officer doesn't have that on hand immediately, he or she still has to provide it, produce it, and make a commitment to say, okay, I will get back to you on that, and they can provide it next week.
Right. And I assume that these documents have to be provided to the public as well through that committee.
Absolutely.
Yeah. Okay.
Yeah.
I think that's one of the things.
Yeah, and again, I go back to we want to see the actual science. It's not good enough. In fact, it's evil to abuse science by using it as a slogan and using it as a slogan with which to beat people over the head. And as Dr. Fauci said in the United States, that to disagree with him is to disagree with science. I don't know if we've had a Canadian politician say that, but it's been the same attitude that if you disagree with these harmful and destructive measures, that you're anti-science. We have to get away from that. We want to see the actual scientific research, the peer-reviewed studies. We want to see those firsthand, so we can look at those ourselves. And there's no reason, there's no excuse for governments not to post those on a website. It's not doxing anybody. They don't contain personal information or names or addresses. It's scientific research. It's public health, and so we need the legislative change to force the government to post that information on the websites.
Good. Yeah, that's one thing I want to see, because of course we had difficulty with that during the pandemic, trying to find the information. Although the Justice Centre, I recall, relied mostly on government information and government statistics, they still had a lot of trouble digging up stuff.
Yeah, we made use. I'm not saying the governments didn't provide any information. There was some information that was provided, and certainly in Alberta, for example, the COVID death statistics were very relevant, very informative, very helpful. They actually disproved the government's case. The government was basing its policies on the false premise that COVID is a serious threat to the entire population, which is false. COVID is a serious threat to elderly people with serious health conditions who are already sick. And the COVID mortality statistics prove this all the time, that people dying of COVID or people dying with COVID were people that were very elderly and very sick. Something, 97% had one or two or three serious comorbidities, for example. So there was some government information, but there was no government information on, historical evidence of successive lockdowns. Would be, I could think of dozens of examples where there's just no evidence to back up the government's policies.
Right. That actually is a good introduction to the next point. This is, let me see, looking at the report, comprehensive reporting that weighs harms and benefits. Tell us a little bit about that.
Well, this is what the National Citizens Inquiry has been doing in recent weeks and will continue to do. It's what the governments ought to have done, and we should change the legislation to require governments to produce a monthly report that will actually talk about the impact of public health measures on physical health. So things like rates of obesity, rates of cancer, access to surgeries, access to diagnostic procedures, mental health, looking at rates of alcoholism, drug abuse, drug overdoses, suicide, spousal abuse, child abuse, financial health, economic health of people. The monthly report by the government should include data on unemployment, rates of bankruptcies, business failures, homelessness. And so we need those monthly reports, and we need to legislate this to force governments to do this, because that forces the discussion. It forces governments to look at both the harms and costs of their policies as well as any benefits that might be coming from those policies.
Yeah, it might be difficult, though, to get them to report bad news. I think that's always been the difficulty with asking governments to report on themselves, especially when you're talking about economic data. And I think that when you were talking about financial well-being, you were talking, I guess, also in the larger sense of macroeconomic data, like how is this going to impact the province, and revenue for the year, that kind of thing.
Well, absolutely. Absolutely. The legislation is important because it guides the executive. I mean, I cannot imagine for a moment that Prime Minister Trudeau would have consented to a public inquiry into his declaration of a national emergency, um, in respect of peaceful protest in Ottawa. But it was the Emergencies Act itself, the legislation said that there must be an inquiry must take place. That was the legislation. Now, if Canada moves further away from being a free and democratic society that respects the rule of law, which means the governments also have to obey the law. If we move further away from that, then conceivably you could have governments simply ignoring the legislation. I suppose that could happen. That would be very bad. But with the Emergencies Act, the government actually complied with the legislation on that narrow point of holding a public inquiry, which did take place. So, in similar fashion, with these, if you legislate a requirement that says that the government must research and produce and release to the public a monthly report, and here's, which must include the following. If that's legislated, you have a higher chance of government doing it than a situation where this is not on the books at all.
I'm not looking ahead yet into the report, but since you brought it up, should we put into legislation the fact that, like the Emergencies Act, at the end of a public health emergency, the government is required to hold an inquiry to find out how they did? I mean, that might be interesting, because I noticed we don't have a government inquiry into Canada's COVID-19 response. We have a citizens inquiry. So maybe we should be forcing the government to do it as well. Although, I guess there are probably arguments for doing it this way as well, right?
No, it's a brilliant idea. I think, seeing as time of recording right now, I still have some wiggle room to make some changes to the submissions. I actually like the idea of that when public health measures have been put in place, that there needs to be an inquiry, that taking place within a certain time period, whether 6 months or 9 months or 12 months, after public health emergency ceases to exist. And there's no reason why that cannot be done federally and provincially. Lord knows there are enough federal government workers and provincial government workers to get the job done.
Yeah.
Need not be a lot of extra money.
Right. And the impact, of course, was tremendous on the country. So I think that it behooves us to gauge how we did. And that's why I think that this inquiry is important. So perhaps we should be doing this as a matter of legislation. Anyways, moving on to your recommendations as they exist before they're amended, just before.
So the right to bodily autonomy needs to be respected.
Okay.
So we need to amend our human rights legislation to state expressly that a person cannot be discriminated against on the basis of his or her prior medical decisions or future plans for medical treatments. And that should include vaccines, as well as any substance that is injected or ingested into the body. So we need that medical privacy, where in the context of receiving goods and services from the public, so if I'm in a store or a restaurant or checking into a hotel, getting onto an airplane, or if one of my kids is going to university, any receipt of a good or a service in the public realm, there has to be that right to privacy, and it should be illegal for employers to discriminate in hiring um, or advancement promotion uh, in regard to whether a person received a particular medical treatment. I mean, obviously, this is going back to mandatory vaccinations where people were thrown out of work, students were expelled from university, people lost their jobs, and a lot of people that didn't lose their jobs were pressured into getting an injection which they did not want to receive. And never again should we go through this kind of vicious discrimination against people based on a legitimate medical choice.
And there, of course, was the denying of unemployment benefits as well. And that's something that, well, I suppose if you weren't forced out of your job, you wouldn't need to be applying for unemployment benefits. Still, I don't think it's a legitimate reason to deny somebody the benefit.
But so you could federally and provincially, we have human rights legislation. So it would not be that difficult to add in. So along with, you cannot discriminate on the basis of gender, religion, skin color, ethnicity, national origin, religion, et cetera, et cetera. You add to that list, you cannot discriminate based on medical treatment, including vaccination, which a person may or may not have received. Okay, and maybe there's better wording, right? They've got, like, the federal parliament, provincial legislatures have lawyers on staff whose full-time job it is to draft legislation, so they can come up with the right wording. But the point is, you just amend the human rights legislation so that denying somebody a job or denying somebody a service, refusing to sell something to somebody, refusing to allow somebody to come into your restaurant, your hotel, board on your airplane, get onto your train, that this kind of thing becomes a Human Rights Act violation for which you can file a complaint. And the complaint against party, if they did discriminate on this basis, they've got to pay, damages or some kind of compensation to the complainant. So we've got the human rights legislation on the books. Let's amend it to really protect people in an area where people were not protected in 2021.
Okay, looking ahead now to the penultimate recommendation, I can tell that this one's a real stink bomb. It is a big one, and it doesn't sound that drastic, but considering the amount of money that is, I guess, handed around during these moments of crisis, it's a big one. Go ahead, John. Tell us about it.
So, proposed contracts that are signed between governments and pharmaceutical companies must be made available to the public prior to being signed, as well as after being signed, by posting this information on a website. Again, there's no right to privacy. You and I, if we had a business contract of some kind, that's your business, my business, it's confidential, and it would be inappropriate for anybody to ask that it be posted on the website. But when it involves the spending of tax dollars, billions of tax dollars, or certainly millions in any event, it's the public's business. The public has a right to know. And so in conjunction with that, there should be no legislated liability for pharmaceuticals. If pharmaceuticals want the advantage of earning fat profits, they have to, like everybody else, they have to also run the risk of liability in the same way that, the car manufacturers, they are profitable. At least some of them are. The ones that are still in business now are presumably are profitable, and that's all well and good. But part and parcel of that is if there was a design problem and the cars are malfunctioning and there's a recall, and you can be sued. Doesn't mean the plaintiff's going to win. You can defend yourself and say that you behaved reasonably. In any event, there's no exemption from liability for other corporations, and it should be no different for pharmaceutical corporations. If they want to earn billions of profits or millions paid for by tax dollars, then they need to suck it up like everybody else and accept that if they get sued for problems with their product, which they ought reasonably to have known about. Again, a lawsuit's not going to guarantee success, but the pharmaceutical companies have to accept that.
Right. So they no liability protection and transparency in the contracts. That's a big one. Anyways, I can say you saved the best for last. Let's go to the last one here and finish up for the day.
So democratic accountability and access to justice. So a lot of the provincial legislatures largely shut down. They could have moved to Zoom a lot earlier. Um, Same with the federal parliament. I mean, for many months, the whole country was being run from the prime minister's cottage, who announced billions in spending from from a summer cottage. The country was run by news releases. Parliament was effectively shunted away. That's not a way for a democracy to function. There has to be accountability there at all times, 365 days a year. In particular, if the government is responding to a public health emergency, public health crisis, that's all the more is the time when the federal parliament, provincial legislatures should be open and running and functioning. And so we need legislative change there to see to it that the public health emergency, it could be an excuse possibly for the MPs or the provincial politicians to not meet in person. Perhaps, maybe, possibly, could be an excuse, but no excuse for shutting down the proceedings.
Right. Yeah. If we can meet online, I'm sure they can as well. And you say access to justice here. Just quickly give us your thoughts on that.
So the courts tragically and unnecessarily shut down to a large extent in March of 2020, and there's no reason to do that. Okay, granted, yes, maybe it would have taken a week or two or three or four to get the technology set up to be a bit better and to facilitate the Zoom hearings, but court actions are court actions, whether it's criminal law, family law, civil litigation with individuals and corporations suing each other, constitutional law, administrative law. It doesn't matter what area of law. We cannot have a situation where people just can't go to court anymore. This is one of the things that makes our country special, a democracy governed by the rule of law. One feature, one aspect of that is that we solve our problems by going to court instead of using baseball bats. There are many countries in the world where you do not resolve your disputes, your conflicts by going to court because the court system is so corrupt, or it's not available, or it's not part of the culture. Judges are bribed, or judges do the government's bidding, et cetera. For any number of reasons, there are countries where what really matters is you've got your own private army to throw your weight around, or if you're not rich enough to have a private army, people will resolve their disputes with baseball bats. And if the courts are not going to be there to provide a peaceful resolution to the conflicts of, mom and dad are divorcing and they're fighting over access to the kids, or you believe that somebody's cheated you out of a sum of money in a business contract, or you're suing the government over charter violations, or there's criminal proceedings with an accused person who claims to be innocent and a victim of crime who says that the accused person's very, very guilty. You need to be able to take that before a court. So it's just there's no excuse for courts kind of shifting into low gear and suddenly refusing to do a lot of work which they had been doing previously. The work of judges, most of the work, yes, there are court hearings, but for every hour that a judge spends in a courtroom, he or she spends 3, 4, 5, 6 hours out of the courtroom. Most of the judges' work is done in their offices when they are reading cases, researching the law, looking at the evidence. So there's really no excuse for courts to slow down.
Right. So courts should have an emergency plan as well. That's good. Okay.
Yes.
Well, great. Thanks, John, for laying it out for us. And I look forward to seeing you in the tape at the inquiry. I don't know whether I'll be able to get down there to see you, but it's, I think, going to be a landmark day for the Justice Centre. Thanks so much for participating in this episode of Justice Centre Weekly. We'll talk to you soon.
Thanks, Kevin. Have a great day.